relate to the Public Protector's remedial action in line with the SARB-Ciex Report, which determined that Absa should pay back a sum of over R1 billion that the South African Reserve Bank failed to recover from Bankorp, which was later acquired by Absa. Now, Mkhwebane is expected to appear in the Pretoria Magistrate Court. That should happen in January. We are now joined by Advocate Paul Hoffman, the Director of Accountability Now. Advocate, good to have you. Welcome to the show.
Good morning, Leanne, and good morning to your viewers. It's a pleasure to be on your show.
Yeah, I know that you are very satisfied with this particular development. Talk to us about it.
So I think it's a good sign that the criminal justice administration is getting back on its feet, having been knocked out during the Zuma era. It's not a difficult case. The Constitutional Court has already decided in a civil appeal that Busisiwe Mkhwebane was fast and loose with the truth on oath in the papers that were filed in that case. And you'll recall that her remedial action, to which you referred in your introduction, was set aside by the courts, and she was ordered to pay a portion of the costs that had been incurred by the Reserve Bank, which she rather bizarrely suggested should have its mandate revised by Parliament, and ordered Parliament to do so. And of course, Absa, a bank, were able to show that it was not appropriate remedial action that she ordered them to repay the apartheid era loans to banks that were in trouble in the dying days of that regime. So while it's taken a while, it's more than a year since we laid the complaint, it is heartening that the Hawks and the National Prosecuting Authority have got to the point where a criminal summons has been issued, and it also opens the way for the President to reconsider our earlier request that the Public Protector be suspended while Parliament makes up its mind as to whether she should be removed from office or not. The Legal Practice Council is also seized with a complaint that she be struck from the role of advocates because she has lied on oath, which is not something that officers of the court are meant to do or are expected to do. And if that were to happen, the striking off would disqualify her from being Public Protector, because she is only the Public Protector by reason of her qualification as an advocate. So if all of this pressure does not persuade her to resign, then I'm afraid there are many strings to the bow to get her out of the office she occupies and enable the Office of the Public Protector to function as it did under her predecessor, Thuli Madonsela.
People would argue with you, and you know, there is a lot of support as well for the Public Protector, and there's also, you know, talk to agendas against her office, and you know, in comparing her to the previous Public Protector that had a lot more support, but this Public Protector also finding that, you know, there are a lot of people that are trying to get her out of office. I mean, we also saw, I think it was a report in the Star earlier this week saying that the President, Ramaphosa, may be also pushing buttons to get her out of court and out of the office. And there's a lot more at play than meets the eye. What do you make of accusations like that?
The report in the Star has been debunked as fake news, and I would be very surprised if our president were to interfere with the prosecution process. You will recall that when he was asked to do so by the leader of the opposition during question time in Parliament, he turned on the leader of the opposition and said, "You must run for the hills when the executive branch of government starts interfering and influencing decisions to prosecute or not to prosecute." It's not the game that he's playing, and his office has put out a media statement saying that this is false. The difficulty that we have with Mkhwebane is that she was handpicked by Jacob Zuma, whose agenda has nothing to do with the advancement of constitutionalism and the promotion of the rule of law. She lied to us, provably lied to us, right at the beginning of this matter in January 2017. We complained to Parliament that she had lied to us and that it also appeared that she was running the investigation in a manner that was both incompetent and contrary to the rules. She didn't appreciate the significance of the other side of the story rule that applies to her, and she did not secure the confidentiality of provisional reports. And the lie that she told to us was that there was no provisional report in our matter, when in fact there was, and we were able to show that there was, together with a covering letter to the president signed by her. When we asked her to explain, she said, "Excuse me, I can't investigate myself," which is really a spurious basis for refusing to account. Now, I agree that exacting accountability is not a popularity contest, and that it is difficult to exact accountability from people who want to behave unaccountably. But when we complained to Parliament in January 2017, which is a long time ago, that the public protector was not prepared to answer 13 questions that we had asked her around her mendacity and incompetence, Parliament did nothing about it. The Justice Portfolio Committee, I might as well have written in Greek to them, because they did not respond. And when they were replaced by a new committee in the new Parliament, we got exactly zero go forward in that department. So that's why we've used the shotgun approach and made the criminal complaint that now leads to these perjury charges, made the Legal Practice Council aware of the fact that one of its advocates has been found to lie on oath by the highest court in the land, and we have taken the matter up with the presidency. We wrote to the presidency yesterday and said it is now time to exercise your discretion to suspend her, because once she is suspended, her influence in that office will dissipate, and it will be able to resume normal service, which is not running to some political agenda, but is there to correct maladministration and to responsively serve the interests of the people of South Africa.
So, Advocate, let's move on to what it was that led you. But one thing I do need to, just in terms of talk to as well, is, I mean, I know what you were saying is that she was handpicked by former President Jacob Zuma. She may have been, but she went through a rigorous process where she was interviewed, and most political parties and most people part of a panel, parties were in favor of her, I think, except for the DA. But everyone else gave her the thumbs up, and she went into the office in any other way that a public protector would go in. But obviously, subsequently, there have been a lot of issues. Let us go back just, why did your organization, Accountability Now, take it upon itself to actually embark on these charges against Mkhwebane?
We did so because we were getting nowhere with the parliamentary committee that exercises oversight over her. That complaint went off in January 2017, and it was not until 2019 that the Constitutional Court became seized of the matter, because it takes time for review proceedings to work their way through the system up to that court. And the finding of the Constitutional Court in the matter about her mendacity on oath really coincided with our complaint that she had lied to us in the manner in which she was handling our queries in relation to our complaint in the SARB-Ciex matter concerning the State Security Agency. So we did what we did because our complaint, which ought to have been investigated by the public protector as an instance of maladministration by the State Security Agency, was allowed by her to morph into an order that Absa Bank pay millions of rands and the direction to Parliament to change the mandate of the Reserve Bank, neither of which had anything to do with the essence of our complaint, which was one of maladministration by the State Security Agency. And we were not sure that the Hawks would spring into action, and we are pleased that they have. And so we also complained to the Legal Practice Council because advocates are not supposed to perjure themselves in affidavits that they present to our courts. And we took the matter up with the presidency and have done so again yesterday because the president has a constitutional discretion to suspend her while Parliament is making up its mind what to do with her.
Other than the case of perjury, do you agree with the view that there might be a case to be investigated on the role of banks looting state funds during apartheid? I mean, if you consider reports from organizations such as Open Secrets that have exposed some of the cases of government funds abuses by the apartheid government.
Yes, we simply cannot understand, and nor has the public protector investigated why the work that was done by the Mbeki administration to uncover the sort of malfeasance that you are talking about was not followed through on. The CIEX, the covert investigative agency run by a retired British spy called Michael Oatley, had consulted senior counsel at the Pretoria Bar, had prepared draft particulars of claim against the banks that you talk about now, and the State Security Agency said, no, don't carry on, we're cancelling this deal, we're not interested in recovering that. That is what ought to have been the subject matter of the Public Protector's report, not a bizarre direction to Parliament to change the Constitution to amend the mandate of the Reserve Bank. And before I forget it, because you slipped it into your previous question and I didn't cover it, there was no rigorous process by which Busisiwe Mkhwebane was elected. She did a good PowerPoint presentation in Parliament. She was not properly investigated. The DA did its own homework and decided that she was bad news, and I'm afraid the DA has been proved right that she is bad news. Everybody thought that a recently retired Justice Siraj Desai was going to be our new public protector in October 2016, but it seems that the president had other ideas and that he appointed a career civil servant who has never acted independently in any part of her career and has unfortunately maintained the habit of working for the executive instead of working for the good of the people in a manner that is without fear, favor, or prejudice, which is what the Constitution requires of her office and which is what Thuli Madonsela was able to bring to bear on the work that she did.
All right. Well, I mean, Advocate, we're not going to argue too much on that, but certainly, I mean, there was a parliamentary process. She did appear, she answered questions, there were votes, there were people that did vote in favor of her. And, you know, as things work of this nature, she was put into that position. Exactly how the previous public protector, Thuli Madonsela, was put into that position. But that's not really what this is about. I mean, now we're moving forward with regard to this particular case and going forward. Your view, and that is that this should be a straightforward case because the original affidavits of the case are filed with the registrar of the Constitutional Court and the judgment is already available online. What do you hope that the court will conclude here?
Well, I'm satisfied that the merits of the case, look, what happened in the Constitutional Court was that it was established on a balance of probabilities that there had been perjury on the part of the public protector, and that is why the adverse comments were put into the judgment by the majority of the court. That finding on a balance of probabilities is not enough to secure a conviction in a criminal case, which is why the Hawks have done their investigating, and they are satisfied that they will be able to prove beyond a reasonable doubt, which is the test in a criminal case, that the public protector is indeed guilty of attempting to mislead the court. They may even add charges of an attempt to defeat the ends of justice to the 3 perjury counts that are already on the charge sheet for the 21st of January. We can anticipate, because of the way that she has been stonewalling the parliamentary process with litigation and appeals and interdicts and attempts at getting interdicts, I should say, that Busisiwe Mkhwebane will make representations to the National Director of Public Prosecutions not to proceed with the case. The National Director will refuse. A refusal will be taken on review. The refusal of the review will be taken on appeal, and the entire process will take almost as long as the balance of her term of office.
Okay.
But one can only hope that the Criminal Justice Administration and the management of the courts is such that that is not allowed to happen. And I don't think it will happen if the President exercises his discretion in favor of suspending the public protector while the parliamentary process for her removal is underway.
We have to leave it there, Advocate. So many more questions to ask, but it is an ongoing issue, and we thank you so much for your time, for joining us. Advocate Paul Hoffman adding his views on developments with regard to the NPA's confirmation that Public Protector Busisiwe Mkhwebane will be facing prosecution on charges of perjury. So that's what we wrap this on, SARB and the Ciex case. That's exactly what we're talking about. But we end now on SABC 2, but the next hour is going to be vital to listen to.
Yeah.